Dear viewers, welcome to this channel. In this episode, we will discuss the legal term Nudum Pactum. Nudum Pactum is a Latin term mean naked agreement or bare promise without consideration. One of the essential conditions of a valid contract is consideration. An agreement without consideration is not legally enforceable nor valid. Nudum Pactum may be oral or written. Lord Mansfield remarked in 1756 that all such agreements without consideration are merely a moral obligation. Nudum Pactum may cause moral obligations but not legal bindings. In English law, Nudum Pactum, that is, an agreement without consideration, is not valid nor enforceable. In US law, the concept of Nudum Pactum is valid and enforceable as similar to the option contract. In English law, there are two types of contract. One, contract with consideration, and two, contract under seal. Contract under seal are valid even though it does not carry consideration. In this context, Justice Schuyler, E.B., in the famous case of Rand versus Hughes, viewed that an agreement without consideration have no legal binding force, and it is a promise which have only moral binding. When we look into the legal administration, viewed further that an agreement not under seal and not having any consideration value, even though in writing, does not bear any legal enforceability. Viewers, please check the description box where I have given link of the various videos. Hope that will meet your interest. I request you to like, share and subscribe the channel and comment in the comment section your views and valuable suggestions. Let us start now. In India, under Section 25 of the Indian Contract Act 1872, a contract without consideration is void. But there are certain exceptions where the contract without consideration is legally binding. 1. Natural love and affection. If the parties to the contract comes under legal obligation out of the natural love and affection, such contract are valid. In this regard, there is a famous as well as an interesting case held in the Calcutta High Court, Rajuluke Dubey versus Bholanath Mukherjee. The relation between the parties to the suit was wife and husband respectively, and it was a bitter relationship. Wife agreed to leave the husband if the husband provide her residence. Wife left the husband, but the husband did not keep his word. Wife filed a suit against the husband. Wife pleaded that though there is no consideration in the contract, but her contract is guided by love and affection. The court held that it was true that there is a relationship between the parties, but love and affection was miles apart. So the wife case failed. 2. Past services. In past, the promisee has served the promisor voluntarily. Promisor promised to pay for the service to the promisee. If the promisor changed his mind, the promisee can enforce the contract. 3. Gift or charity. Gift or charity includes the transfer of movable and immovable property one to the another without consideration. Such transfer or agreement or contract is valid under law. 4. Agency. As to the Indian Contract Act, no consideration is necessary for the creation of agency. 5. Bailment. Bailment contract under the Indian Contract Act includes or mean a product or commodity passes from one person to another for a particular purpose, and it returns back to the original person or owner after the completion of the purpose. So, the consideration is not necessary in bailment contract, but it is a valid contract under law. Now let us put the entire episode in a nutshell. Nudum Pactum mean a bare promise or a naked agreement. That is an agreement without consideration. An agreement without consideration is not valid, neither in English law nor in Indian law. Nudum Pactum can bring moral responsibility, but not legal enforceability.